We have a panel of experts who know an awful lot about the art of the deal and regulation by it. We'll start with, and I'll introduce them pursuant to Naomi's instructions. Very, very briefly, their illustrious biographies are in your little booklet. We'll start with Stephen Davidoff-Solomon, and then we'll go in the following order, if I remember this correctly, actually in the order in which we're sitting. Reg Brown will go next, Bimal Patel, and Heath will clean up. We'll have 10 minutes each, brief panel discussion, lots of time for questions. Steve, please.
Great. So if you could just get me on the 10 minutes, I'd appreciate it. I'm very happy to be here, and I'm very happy in some ways that I didn't plan to be here with the change of administration that we're having, which makes life very interesting. And so I think I will, what I'm going to do is talk about my paper and sort of talk about sort of the implications for regulatory reform that is on the horizon. A long time ago, really, in 2008, I wrote a paper with David Zaring called Regulation by Deal. And what we tried to do was to put some theoretical gloss onto what we saw, what was going on at the financial crisis. At the time, looking at the bailouts and looking at the structuring of what the administrative response was, we thought it was deal-making. And deal-making is different than what governments normally do, or at least the theoretical models we had seen before, which really are about notice and comment, due process, the administrative state, executive action. Really what we saw going on, instead of any of those, was very quick action by the government to do deals, hiring expert lawyers, hiring expert investment banks, acting on a very quick basis, documenting the deal through contracts that were looked very much like my prior life as an M&A lawyer at a big law firm, we didn't have a normative view on regulation by deal at the time, but we thought it worked well enough. Now we can talk about, the exigencies of the financial crisis, whether it was right to bail out certain groups or not, whether they should have gone into bankruptcy, but that wasn't really the purpose of what we were trying to do at the time. What we were trying to do at the time was to describe what was going on and look at it from the sense of was it working to affect the government's program, which was to stem the financial crisis. And indeed it did work spectacularly. Financial crisis was resolved. Again, I'm not saying it was resolved in the way people wanted it to be resolved or the most effective way it would have been, but it was addressed. And so what we wanted to do sort of with this conference is take that normative approach of looking at what was going on, regulation by deal, and do a couple things. In this newest paper, which we're revising, and I've taken on my old co-author David Zaring with, what we're trying to do is sort of do something a little broader. And that is, namely, look at sort of regulation by deal as sort of in the new administrative state and see how deal-making can and can't be done on a going forward basis, both within the financial crisis apparatus and without, okay? And so in my last sort of few minutes, that's what I'm going to talk about is both those normative perspectives. So in the financial crisis, the sort of catchy phrase that we have in this paper is regulation by deal illegal, right? And so we've set up in Dodd-Frank a system where we have a systemic regulator, which was not very popular on the last panel, and we have also a system where we have a quasi-bankruptcy regime for systemically important institutions. It is my belief, even if it persists, and likely it will be hard to overturn, but even if it persists, this is a regime that will never be used. It's complicated, it's bulky, you need a whole approval process. In the heat of a financial crisis, the key to solving a financial crisis, which we've known for hundreds of years now, is liquidity. You need to get liquidity into the system as soon as possible. Having a sort of separate bankruptcy process that creates sort of a liquidation of immediate liquidation of a big institution, and a cumbersome process is never used, which can be risky in and of itself, is not going to solve that liquidity problem. So in terms of sort of solving regulation by deal when the next financial crisis comes, essentially we have the issue of the Fed, Treasury are going to try and pump liquidity into the system as much as possible. They're going to rely on Section 13, which is sort of the mainstay. If they can't rely on Section 13, one of the things we go through in our papers is how the law was stretched, if not broken, during the financial crisis. So a good example is the money market bailout was based upon the Gold Reserve Act of 1932, which had nothing to do with money markets or otherwise, but the government was looking for a bare legal hook to justify that. And in a financial crisis, when the government's looking for any hook that it can, it will rely on Section 13, it will rely on whatever it can to get those funds into the system immediately, which raises the issue of how to cabin that. And that sort of goes to the second sort of broader issue which we're noodling on, which is, well, what about regulation by deal generally, right? So we have a Trump presidency. He wrote The Art of the Deal. He hasn't been a crazy successful deal maker. If you actually look at what he has a hodgepodge of real estate investments that sort of don't make sense together. But government going forward is going to be more of a deal maker, even in either presidency. And the reason why is because the administrative state can be cumbersome. We're seeing that in sort of executive orders. We're seeing workarounds in executive orders. Regulation by deal is more permanent because it involves sort of contractual relations and other relations that sort of can cement these things. And so going forward, we're going to see more types of one-off deals just outside the financial crisis generally. And so that leads to sort of the ultimate issue, which is, do we think regulation by deal is appropriate? And if so, or if not, how do we cabin it? In the financial crisis sphere, I don't think you're ever going to stop it. I think things are moving so fast, and the executive is going to move so fast. You're never going to stop it. I think the best you can do is put speed brakes on it, and we're still sort of noodling on what those speed brakes would look like. But they could rely on one suggestion we had at a prior conference was a legal opinion from counsel. We think, generally speaking, sort of paving a rule of the road, which is you can give liquidity if you meet XYZ tests, is sort of a better way to do it, and make those tests very clear. But if anyone has any suggestions on this panel, we're sort of still trying to figure out how that would work in practice in a replacement for sort of the Dodd-Frank apparatus that exists today. And then regulation by deal generally, it's just hard to get rid of. I think the best we're going to do is do a normative basis so we know what it is when we see it. And we'll be seeing it a lot, I suspect, as we go forward. So no easy answers, unfortunately.
So thanks, Stephen. I took the question, is regulation by deal legal, and reframed it the way that a practitioner might want to frame it, which is, does it raise legal questions? And the answer is, of course, it does, and you've highlighted a number of them. I'm going to try to, in my time, just provide a very limited defense of my former colleagues in government that were tasked with responding to the financial crisis. I'm going to make the argument that there are exigent circumstances that ultimately the so-called victims in the three areas that you identified are really not that sympathetic. And then third, that there are real political checks on abuse. And then in classic form of a practitioner, I'm going to suggest there's a big shiny problem over here that's way more important that we should focus on. So let me take those in order. Exigent circumstances. Obviously, during the financial crisis, there was tremendous, extraordinary uncertainty. People did not know whether they were going to be able to withdraw money from the ATM on Monday, and it was week after week, and it became more and more pronounced, and the like. And so there was a sense that someone needed to act. I think that they tried to act with reference to law, which, as I'm going to suggest later, is an improvement over what is done in some other areas. So in every instance that I think I focused on, one related to Fannie and Freddie, another related to AIG, and the third related to money markets, they did try to go find the law. There were lawyers involved, and they spent time looking at these issues, and that is one form of a restraint. I think under the Gold Reserve Act, you had to get an opinion from the president before you were allowed to make investments in a particular way, and they did all the things that they were supposed to do. And a lot of that's chronicled in the work of the Financial Crisis Inquiry Commission, which Peter Walson served on, and I tried to thwart, not as successfully as my clients would have liked, but nevertheless. In terms of the victims, I really just don't have that much sympathy for the aggrieved parties. The shareholders of Fannie and Freddie, Peter has talked for many years about the sort of model of private gain and socialized losses that sort of allowed the Fannie Freddie machine to kind of go for years upon years. And there were folks in the government, myself included, who tried to stop that, and we weren't able to do so. So now that some shareholders feel aggrieved that the losses are falling on them and are not being socialized, do I really care? No, I don't. Second, I'm speaking for myself, not for my firm or any of our clients. I should add. Second, on AIG, the reality is AIG probably would have gone bankrupt, and the bailout there really benefited some of the counterparties as much as it did AIG. And Starr didn't really raise that much of a fuss until after he saw how it worked out. So not an awful lot of sympathy there. And then the truth is, on the money markets, I'm just selfishly glad that the government acted to protect my very heavy and cash equivalent 401k, even if they had to use the Gold Reserve Act to do it. So I won't give you a principal defense of that, but most people are very happy that their 401ks are just fine. But there were constraints. There were short-term constraints. You'll remember that Paulson and the folks that work for him got hauled up before Congress on a regular basis. Company CEOs had to go in and raise their right hand and answer questions on their oath. People's bonuses were stripped. They were forced to take the shuttle commercially or to take the train rather than to fly on their private jets. There were short-term checks on the behavior. Longer term, we got SIGTARP out of it. Unfortunately for the industry, you got Dodd-Frank, and ultimately the national mortgage settlement, which I think was a true abomination, where frankly 3 very innocent banks, Wells, JPM, and Bank of America, all of whom were asked by the government to acquire institutions that had done pretty horrible things, and then forced to settle and pay out billions and billions of dollars of shareholder funds for the sins that had occurred beforehand. That is in itself probably the biggest deterrent to the banks being willing signatories to future deals. In my mind. And then last, of course, but not least, the financial crisis gave us Liz Warren, which is the gift that continues to give from my perspective. So there were political checks on it, and I think that the likelihood of it happening again is relatively low, but it is useful to talk about ways in which you could constrain regulation by deal. The bigger problem, in my view, is not regulation by deal, but regulation by enforcement, which is taking place in plain sight at the CFPB today. Concepts like sue and settle, which I think the Chamber of Commerce has written about, been used in the environmental context in some really, really horrific ways, but could also be extended to the financial services arena, where there are no exigent circumstances, rulemaking is available, and people just choose to do other. And what do I mean by regulation by enforcement? I'll be really quick because I know the time is limited. What I focus on there is consent orders. And the sort of classic example in my mind was the CFPB forcing for auto companies, through their lending arms, to enter into settlements based on disparate impact theories to limit the discretion that the dealers that they work with, who were by law exempted from regulation by the CFPB, to take less money in terms of markups for transactions that they were involved in. It was outrageous on lots of levels. First of all, the disparate impact theory wasn't even based on race. It was based on a proxy for race, and the proxy was, I think, last name and address. My last name is Brown. My wife, who's also African American, has the last name of Sanchez for some weird historical reason, and we live on a street called Mansion Drive. I have no earthly idea what race category we were put in for purposes of the settlement, but I have not gotten a check. And I'm very, very upset, about that. So you had a flawed proxy to start, and then you had rulemaking. And what's extraordinary here, and I'll end on this, is you actually had a memo that was uncovered by Congress in 2013 that laid bare what it was the CFPB was doing when it acted by consent order as opposed to rulemaking to determine how much discretion would be allowed in markups. The memo says, and I'm going to quote from it because it's just so beautiful, and it's probably Exhibit A in the case for removing Cordray for neglect of duty or malfeasance or something like that. It's April 3rd, 2013. First, the legal authority for all of the potential rulemakings is unclear, given our lack of authority over dealers. Second, the Bureau would face considerable pressure from external groups if it sought to regulate or ban the practice of markup itself, pressure that should not be underestimated. The rule could be perceived as an attempt to circumvent our lack of regulatory authority, and that presents both legal and political risks that our rule could be overturned by a court or by Congress. So the Bureau specifically acknowledged that if it proceeded by rulemaking, it might be in trouble because the courts and or Congress could weigh in and overrule them, and specifically acknowledged that it had grave doubts about its own authority. And so what did it do? It regulated by enforcement order against companies that couldn't handle the publicity of being accused wrongly, I believe, of discrimination. That, in my view, is a much larger problem than the problem of regulation by deal under exigent circumstances.
Thank you. Vimal?
So I am going to disagree with a piece of Professor Solomon's thesis, specifically that regulation by deal should be permitted in times of crisis, and then you should normalize and return to traditional principles of administrative law when you're not in crisis. I should start with the caveat that I'm giving you this view, so to speak, from the cheap seats, because my government service occurred in the aftermath of Dodd-Frank and in the wake of the reform. I wasn't in the government during the financial crisis, and so to borrow a metaphor from Paul Tucker, who was the deputy governor of the Bank of England, I did my government service during peacetime rather than wartime, and maybe if I hadn't done that, I'd have a different view on what I'm about to say. I think, it's fairly easy, and I'll do this quickly, to go through a number of reasons why regulation by deal is problematical. I mean, I think it all begins with my view that the rule of law is one of the most important principles under which our government operates. It is how we create property rights. It is how we create expectation interests. And the concept of regulation by deal, in my view, impinges upon those fundamental notions in a number of ways. So just to give you a couple examples, for one, if the same text is purposefully read to mean different things in different circumstances, that can create all kinds of inefficiencies, can create malaligned incentives, it can create deadweight losses. Regulation by deal is problematical on a micro level because it leaves, for example, open the question of when are we in a crisis scenario that gives us the moral authority and arguably the legal to to sort of circumvent the Administrative Procedure Act and other more traditional notions of administrative practice. That's an open question. We can, governing fundamentally is about line drawing, and when you leave that much to the imagination, there are open questions there that need to be resolved. Likewise, when you function in a common law legal system, if you have one set of precedents for wartime, to borrow from Paul Tucker, and one set of precedents for peacetime, how are young lawyers going to research on Westlaw and write briefs? Well, but you can't cite to this case because we're not in a sufficient emergency. So that has relatively less precedential value. I wouldn't want to have to try to finesse that oral argument in court. And finally, consequentially, regulation by deal, and Professor Solomon makes reference to this in the paper, effectively allows the government in some sense to pick winners and losers based on what the terms of the deal are. If you have, for example, a fact pattern where two firms at different times in history have the same safety and soundness problem or make the same management error, and at one point it's an idiosyncratic event that can be contained by letting the market punish the debt holders and equity holders of that firm. And at a different time, it's a systemic event where that happens to multiple firms. If the government is more likely to intervene in the latter, is that the right result? I mean, obviously that's a theoretical question, but the concept of having the government choose winners and losers leaves me somewhat unsatisfied. So, okay, I've just, thrown up a bunch of mud on the wall, but I don't want to be the party of no, so I will offer you an alternative. I think the solution has two parts. I think one part of the solution is during wartime, I think I would prefer a situation where as many of these decisions as is possible can be given to elected officials. That is, if the law doesn't allow something, or the better reading of the law doesn't allow something, go to the Congress and the President of the United States and have them change it. This is, I think, a micro point of a bigger picture, which is one of the things that's going on in financial regulation is you're getting more and more responsibility and power in the hands of administrative agencies that are not elected. And a lot of times, they're not appropriated and so on and so forth. And I would like to return some of the power to the people's elected representatives and the president, because I think that's fundamentally what democracy is about. And I think this is a good case study with which to do that. The second solution I offer you is that, just underscores the importance, from my perspective, of trying to prevent a crisis to begin with. I think if nothing else, Professor Solomon's paper and the case studies shed light on the fact that we should really be trying to return to a market-based financial system that imposes market discipline, that is led in intent and goal by economic growth, rather than a system that is sort of over-regulated, where we believe we can effectively police as a society and as a government all of the activities in what is a very complicated financial system that spans a lot of activities. And so I would remind us about market discipline and economic growth. And the last thing I'll say before I turn it over to our sluggard cleanup hitter is, we're at a law school, so I have to give you some theory and some academia. And I think the way I want to do that is to say, what I'm effectively advocating for is rule of law and democratic accountability on one side of the scale being preferenced over efficiency. And you might say, well, in a crisis, that's not a good idea. And you know, we can sort of debate that, but I would at least argue that, at least on my read, the founding fathers sort of set our system up in a way, if you look at sort of the supermajority constraints, and you look at, you know, the veto power and the 2/3 overrides, and so many, I mean, you could go through the Federalist Papers and pick out so many implementation mechanisms to prevent tyranny of the majority that I would argue they chose and wanted democratic accountability and the rule of law to supersede, you know, temporary notions of efficiency. And for that reason, yes, I tie that principle back to the argument that I'm sort of making here. With that, I will cede and welcome your questions.
Thanks so much. Heath?
Sure. So I guess I'll end the. There's not much I can really add to this great group of speakers, other than to say, I guess, picking up on what some of they said. I actually did serve in wartime rather than peacetime. The Gold Act and the money market mutual fund thing was brought up twice, and I was, if that was wartime, then that specific instance was like our Omaha Beach, the U.S. government's sort of initial intervention using pre-TARP authorities. You know, in the Bush administration, the president was very much a rule of law president. He cared about the Constitution, he cared about the laws. So in that particular instance, it was actually my job to review the plan that had been proposed by Treasury to ensure that it in fact did work, that legally it worked. And you know, my conclusion is that it was actually not that very difficult of a case. The Gold Act created the Exchange Stabilization Fund, and the point of that was to stabilize the US dollar. My analysis was helped by the fact that the Clinton administration had used this same tool to stabilize the peso. So if they in fact had used it to stabilize the peso, and that was a clear binding, that was a clear precedent on the books, then certainly if our money market funds and Ireland and a number of other countries had actually moved to guarantee their money market funds, which would cause withdrawal of dollar-denominated assets over to Europe. So in terms of the legal justification, I didn't have an issue with that. I guess what we always did in the White House counsel's office, at least, was to divide between sort of legal answers or legal questions and prudential questions. You know, the legal question is it legal, is it permissible, etc. The prudential question is it the right thing to do? My role was really just simply to answer the first question. The policymakers answered the second, and I realize there's disagreement on that. What I would say is that it shouldn't surprise any of us in this room that when government is at the table making a deal, dealing on its, on behalf of itself, it will necessarily take an approach towards the law, towards the regulatory framework that favors it, right? That shouldn't be a surprise here. And so I generally agree that, absent exigent circumstances, we don't want our government making rules and regulations, or at least setting precedents that have that effect, because while they're actually at the table and have an interest, there's not the administrative law process, there's not the transparency, and there's not the sort of the framework where many multiple interests and other public policy objectives are taken into account. That leaves me with a vignette that there's still rulemaking by deal in another sense, and in fact I had a situation where we had statutory making by deal. I was representing during the Dodd-Frank Act about 2010 a private equity firm, and the private equity firm was investing in a bank about $12 billion consolidated, located in the Pacific Northwest. And the bank was in real trouble. And if this investment, this capital infusion was not made, the FDIC would possibly be left with a receivership on their hands. We went into the FDIC to discuss the matter, discuss the investment. They were very pleased that my client was about to make this investment, when we got a news flash that the Collins Amendment, which became Section 171 of the Dodd-Frank Act, had been proposed. The Collins Amendment basically strips a number of capital instruments from the holding company. It basically equates the capital, the same kinds of forms of capital that are used at the depository institution are the only ones that can be used at the holding company. What it did in this particular case was eliminate a whole set of capital instruments from the holding company, which had the effect in my situation of basically destroying the proposed deal. There was a grandfather clause in the proposed Collins Amendment of $10 billion. If you were under $10 billion, it didn't apply. If you were over $10 billion, you lost these capital instruments. We had a $12 billion bank. The FDIC had proposed the Collins Amendment, actually sent it to Senator Collins. She sort of, took part of the credit for it. She put it forward, but ultimately it had been drafted by the FDIC. Told the FDIC, sorry, we can't go through with this deal. Years later, I found out, a phone call was made a day or two later. Senator Collins, how are you? You know where it says 10 billion? Could you scratch that off and write 15 billion? That's what happened. So that's an example of where sort of a statute, effectively a provision, was created by deal. But we do have regulation by deal in another sense, where the government is not the actual participant in the deal, but the government is essentially creating regulations, rules, precedents based on deals that are brought before it. And sort of to make a pivot similar to Reg has made, this is an area that I think warrants further academic study. The Volcker Rule, for example, is 1,000 pages, but it can't possibly address all of the situations that arise in the real world. They simply weren't thinking of them. They couldn't think of them. Some of them are new. They're based on innovation. And so every day, lawyers like us go before the Fed, the FDIC, the OCC, other regulators, and say, we have this transaction. The law says this. We think this transaction fits within that, or an exception should be made for X, Y, and Z reasons. The regulators, often through a no-action letter or through a legal opinion, will basically issue a statement, and as a result, you have regulation by deal. It's a specific deal that creates a new precedent. Well, what we've noticed over the last few years is that that process is sort of stopping. We've had sort of a common law that's developed. And now what we have is not law, but lore. And I'm not sort of mimicking a New York lawyer saying the word lore, but rather like folklore, a sort of a lore, where you don't have anything written down, and you call up, let's say, the Federal Reserve, and there's a particular lawyer in charge of this area, this statute, and they say something like, well, John isn't comfortable with that. And I say, well, look, we're not buying John a sofa. This is a transaction. We're asking you to put forth a precedent. And that's the sort of answer we get back. And I think that lack of transparency, that opaqueness, is something where we should think about perhaps a different study in academics. So there is also regulation by deal, where government is not the participant in the deal, but it's an area that's very important because it affects the financial system, it affects innovation, and it affects sort of the day-to-day work that people like me do. So with that, I will turn it back over.
Thanks a bunch. I would like to go sort of one more round, and in particular give Stephen a chance to respond to some of the comments. Just want to ask one question. I hate to sound like Adrian Vermeule or something, but there seems to be a consensus that, in a crisis, I mean, you want to have some law, right, as much as you probably can, recognizing maybe that it won't stand up. Why should there be any law? And the reason why I'm saying that is, I think it was a good thing probably that Hank Paulson was the Treasury Secretary when it happened, right? Because he didn't do anything that he hadn't already done at Goldman Sachs. Buy, sell, screw them, and in any event, keep them guessing. And so when there's a legal basis, it suggests sort of consistency and an expectation in the markets that you will do the second time around what you did the first time around, which, if you are in the business of deal making, is probably the last thing that you want. So maybe the way one ought to think about this is sort of wartime, and then try to get back to regularity and stable expectations as soon as you can. Or is that the right way to think about it? Or is this more like a continuum in the sense that, every crisis and every extraordinary legal interpretation sort of normalizes behavior that was previously unacceptable?
Well, I very much appreciate these comments. Where to start? I think so. I think just building off of your point, I think what we decided was when we looked at this. I mean, Adrian and Eric Posner sort of come out with this idea that, you know, in wartime and in crisis, the executive power rules and law goes away. And we looked at this and we saw actually the law was very important during the financial crisis. And I think, you know, you can't do away with law. I mean, we have laws in wartime, we have laws in now, and that's a good thing. I mean, I'm not saying this just because I'm a law professor and I need a job. I mean, it's a good thing that we sort of regulate and give consistency and expectations, because that's what we do in a normalized society. And even in a crisis, the law is going to dominate. I would probably not have been, and again, I was an observer at the time. My main role was as a columnist for the New York Times during that, writing about this and sort of speaking to people. I still remember being in an apple field the day that the weekend Morgan Stanley was going down, speaking to the general counsel, trying to figure out what was going on. So it was definitely a cloudy time for everyone, I think, even people in the midst of it. But I do think that there was an attempt to follow the law. But I think that, and I don't mean to be mean perhaps on the Gold Reserve Act, but I think if this had been done in a non-crisis situation, a court would have struck it down. Now, we don't know that. It struck me as sort of a stretch. I think, you know, a lot of the legal interpretations were novel, at least. I think we can admit that, certainly. They had been untested because they were pushing it. And I think the idea behind regulation by deal and what happened during the financial crisis was there was a real need to follow the law. And I don't know what else they would have done. So to the point about sort of regulation by deal should be illegal, I think it'd be nice to just do that, but I don't think you're ever going to be able to do that in a crisis, because things are going to need to get done. And so the best we're going to be able to do is, again, I sort of come out of this from two perspectives, which is one, let's create pathways. There will inevitably be a financial crisis. It might be 50 years from now. I have no idea how form it will take, but let's try and create pathways in terms of liquidity and otherwise for people to act on sort of a regulated basis with at least some type of maybe ex post facto review to at least get there, number one. Number two, I think that my biggest complaint about regulation by deal was it was deal making. And when you do deal making, you create rigid structures. And rigid structures don't work well in the future. So all the deals were renegotiated multiple times, and to sort of as circumstances change. And so if when you lapse into regulation by deal in a financial crisis, the other thing to think about is sort of flexibility going forward and not binding the government to the extent that you would otherwise. The litigation over Fannie and Freddie is still ongoing because of sort of steps the government took at the time that they seized the entities.
So, after listening to what everyone had to say, I want to strengthen the position. I think that actually it wasn't regulation by deal. It was regulation under the rule of law and deals under the rule of law. Because I haven't heard a terribly compelling argument that the law was not at the center of decisions. Yes, you had Hank Paulson to say this is what I would like to do, but alongside Hank Paulson, you had Bob Hoyt at the Treasury Department and Scott Alvarez at the Federal Reserve, and Heath in the White House, actually writing memos, thinking about what the law required. You had Section 13 authority that was discussed in connection with the AIG matter. You had conservatorship law in connection with Fannie and Freddie, and there's the Gold Reserve Act. And whether or not they were right about things, I think there's really no way to know for sure. But at least from what we can see now in the cases, they had good faith arguments that what they did was lawful, and in fact they haven't lost in a meaningful way. Obviously in AIG, there was a loss, and there's a discussion now that there are no damages.
Nor would I expect them to lose in a financial. I mean, like the courts are not going to step in.
But the court decisions were later in time, and so far, the sort of rulemaking, the deals have been, at least in part, upheld. So that suggests that there was an attempt, at least, to follow a rule of law, unlike, I think, what you're seeing in the case of the CFPB today and some of the law-related activity that's going on at the Federal Reserve.
So I will offer a supplement to my earlier comments. By the way, I agree, and I agreed before hearing these comments, that it does speak well of our system that people were mindful of law. And my comments were not necessarily intended as an up or down vote on whether or not I believe the law was followed in each of Professor Solomon's 3 case studies. I was aiming with my comments to say, okay, if you're in a future situation where one has made the judgment that the law does not allow particular action or remedy in the case of a crisis, you know, what would the consequences be if we nevertheless did it anyway, and what alternatives do we have? So I was trying to be sort of prospective rather than retrospective. And I will reiterate, I think it does speak well of our society generally that we had Bob and Scott and Heath and people, you know, were actively discussing this. And during my time in the government in peacetime, this was an important part of the post-Dodd-Frank rulemakings that we had. So, you know, there was one instance in which a particular rule was being contemplated by the agencies where there were dissenting votes on the basis of the fact that we did not believe that it was consistent as proposed with DC Circuit precedent. So I will cede to Heath, but I do smile at the prominence of the rule of law in our government society generally.
Well, and I'll use that to take on what I hope, but I'm sure it was a polemical question as opposed to you know, your actual views, as you know, that you started off with. Why do we even need rule of law? You know, why not just look, if it's a crisis, you do whatever you need to do? Well, I think you know, Friedrich Hayek and a number of thinkers who most people in this room would identify with, you know, really made the point that a rule of law is the cornerstone of a free society and a free market economy. And so we must have rule of law. We must have a certain degree of specificity, because that predictability is what's necessary to get decisions made in society. If ultimately, you know, well, it doesn't matter whether you open a business, whether you buy a house, the commissar will decide your fate. That's not a way that you have a free society. That's not a way that you generate investment, innovation, capital, everything. So you've got to have the rule of law, and I think that needs to apply to the government just as well. The example I'd use is actually not the crisis, but the Dodd-Frank Act. The Dodd-Frank Act was passed in 2010, but literally we still don't have the final rules. And what I've seen over the last 5 to 6 years are companies, banks in the United States, in America's heartland, way far off in Asia, not making investment decisions, not going forward with plans for expansion, for innovation, because they don't have the predictability of final rules. And so I think it's absolutely critical that we do have a rule of law, that we learn from the lessons of the crisis, but my view is that we need to incorporate the crisis, the lessons learned, into a legal framework to govern you know, those activities in the future. Because without that, you know, we're going to see much of the innovation and investment come to a grinding halt.
It's the winners and losers problem that I think is probably most pronounced in a sort of law-free environment, and you know, I have concerns about that now. I mean, there was, I think, probably a Solomonic decision after watching what happened with one loser. And that weekend, I was on a boat with the General Counsel for the Treasury Department sailing down the Potomac, and I now wish they had perhaps spent that time saving Lena. There was a decision after that one loss that there will be no more losers on some level, and they attempted at least to basically save the whole system. And in the one area where they thought that they didn't have the authority, right, they didn't appropriate funds on their own, they did go to Congress for the TARP Act. So that is another kind of data point that suggests that they weren't operating in a law-free environment, as opposed to, say, the current administration that when it didn't have the funds to do some things it wanted to do under the Affordable Care Act, just simply moved the funds from bucket A to bucket B, which the courts have now said was absolutely unlawful.
I have a lot more questions, but I think we should let the audience go first. So if there are any questions, please raise your hands. And yes, ma'am. There should be a microphone someplace. If there's not, you'll have to yell. Here it comes.
The conversation evolved from the regulation by deal in the context Stephen was talking about, which is this wartime activity, to others alluding to the way we end up seeing regulators using their authority through mechanisms that involve less transparency and less accountability outside of wartime, whether it's enforcement orders, whether it's through the supervisory processes. And I wonder if there are concerns or thoughts regarding the proposals that we've seen for more robust cost-benefit analyses in financial regulation, whether an unintended consequence of that type of rule might be even greater tendency than we've already seen by regulators to use these alternative mechanisms as ways of effectively regulating or exercising their power.
Sure.
You want to go? I can go, Stephen. Yeah, I can try on that one. So I think I'm less. I've never been. So regulation by deal outside of sort of wartime, I sort of think we should limit it. State by state, because it sort of defies the sort of normal administrative process of notice, comment, etc. And so that, to the extent that bleeds into a cost-benefit analysis and you have sort of backdoor regulation coming in or deal-making coming in, cost-benefit analysis is a good thing, right, in most cases. The reason why you have regulation is to sort of solve tragedy of common issues, other issues, sort of benefit society generally, so doing cost-benefit analysis is a good thing. The SEC has been, even though they're supposedly exempt, has been sort of subject to cost-benefit analysis, and that's also been a good thing. I guess the question is what type of cost-benefit analysis do you impose, and sort of how do you do it in dynamic financial markets where it's hard to sort of assess the benefits. I think we see oftentimes regulators sort of take leaps of faith on the benefits, and the question is sort of how tight do we want to be on those benefits.
So I would say that there's a risk of that happening, that people are being afraid they won't be able to win in a cost-benefit world, and therefore they go through the consent order world. But consent orders are supposed to be approved by judges, and I think there is a case to be made that judges ought to, sort of look more closely at what's being accomplished through consent orders and ask more questions. I also think it would be interesting if there were a norm that, say, before a consent order could go through, you had to send a copy of it to OMB and let it sit there for 30 days for people to weigh in, where they might raise cost-benefit issues and the like, and therefore, eliminate the ability to circumvent things through that. So I think there are other ways to address the problem of rogue regulators trying to regulate by deal in peacetime.
So, I used to work at OIRA in the Office of Management and Budget. And, I'll start my response to this with banking is different, and it's different for the reason Peter Wallison identified in the last panel, which is, you have insured deposits in the Federal Reserve's discount window to which banks have access, but other firms in the economy do not. And so, you sort of have to flip logic on its head a little bit with respect to what at least prudential banking regulation should be about, right? It should be about conditioning and narrowing the scope of a subsidy and a public safety net. And the way to do the math on that is a little bit more, I don't want to say it's more difficult, but it's different. You know, if you're sort of weighing the costs and benefits of an environmental regulation, and you say, okay, well, you know, there's X percentage less likelihood of death because there's less pollutants, and the value of a life saved, you know, if it's a person of this age is X, you can sort of run all those numbers and ultimately come up with some answer. In the case of banking regulation, let's take capital regulation. I mean, what is the cost to a bank of, you know, having an extra percentage point of equity? I mean, it loses the benefit of the debt shield, the deductibility of its interest on debt. You know, it may be more expensive to raise equity versus debt in a certain set of circumstances. But, you know, if that means less taxpayer losses in the, you know, X sigma scenario, how do you weigh all that, right? That's what makes it challenging, not just on the cost-benefit side, but on the regulation side, because you get into a real honest debate about what is free market, where you have this safety net that doesn't exist in other industries.
Yeah, so I would echo. I mean, I think it's an important. I personally favor cost-benefit analysis. I think economic analysis is important. I think it makes rules stronger rather than weaker and more effective. But I don't think it should be used as some kind of barrier to regulations. If it's just simply thrown out there to thwart a regulatory framework from happening, then I think you will see the kind of misdeeds that you're alluding to. There are agencies that use tools like interpretive letters, things of that nature. I won't name any agencies, but they've you know, in the recent past have boldly extended their jurisdiction through fancy footwork and whatnot. And in fact, these are the sorts of things that should be done through, you know, the notice and comment rulemaking process. I do think there are challenges, as Bimmel's pointing out. Let's take systemic risk. If on the one hand, the question is, should we subject this company by designating them as a systemically important non-bank financial institution, subject them to Federal Reserve supervision and a new layer of capital and liquidity requirements? Is that going to be, you know, burdensome to the company? Well, of course, but if the company fails and the financial system, you know, collapses, well, if that's on the other side of the equation, well, then that will yield to designation all the time. So I do think we need some clear rules regarding what you do balance in cost-benefit analysis, and that's something where I think Congress should make its voice known and actually have a role in all of this, as it should anyhow, in not delegating its full legislative authority to these agencies to begin with.
Yes, sir.
Hi, Chad Reese from the Mercatus Center. I think most of the conversation has sort of been about, in wartime, is X appropriate or is Y appropriate? If I can kind of ask the panel to go up one step and maybe talk about how we determine if we're in wartime or what that looks like. It strikes me that in a globalized economy, a dedicated policymaker could find some crisis somewhere in a financial structure that might justify this deal or that sort of thing. So I just would love to get the panel's thoughts on, is the administrative law structure that we have in the financial regulatory world sufficient, and does it clearly define what those boundaries should be, or do we need to be thinking about how to determine whether we're in a crisis or not before we determine what kinds of activities are appropriate in a crisis that may not otherwise be?
I'll just punt and say, you know it when you see it. And I think that we really were in a crisis in 2008, and I can imagine a world where cybersecurity issues create another kind of crisis where the government just simply has to act, and there is no time to rely on Congress and the like. So I don't think there's a bright line as to what's a crisis that warrants wartime approaches and what isn't.
You know, I referred to this in my opening. I I mean, this was one of the challenges to me of regulation by deal, is that, you know, what constitutes wartime and peacetime, and is it on a sliding scale? Like, if it's a really big war, you know, does that justify sort of looser interpretations of law? And I don't have a great answer for you on how to define that. I would just take the easy way out, like I did in my remarks, and say, this is why when we know we're in peacetime moments, we need to do everything we can to calibrate policy to achieve ends such as economic growth and market discipline.
Yeah, I'm afraid I don't have too much to add. Some of it will be left up to the discretion of our leaders, which is ultimately what we want. But I would say that your point is a valid one, because when I go back to the Gold Reserve Act example, you know, had the federal government not taken the position that was viewed as binding from the federal government during the Clinton years of using the Exchange Stabilization Fund to bail out the Mexican peso, you know, then it would have been a lot more challenging for me as a lawyer to sort of say, well, this is what the statute says, it's never been used before, could it be used in this context? But having a precedent like that was used in, I think we would all agree, peacetime, at least the way we're defining wartime, you know, laid that groundwork for the kind of legal interpretation that was then used during wartime.
There's another question here, please. 1, 2. Thanks.
So the touchstone of a contract is a voluntary negotiation, typically done at arm's length. It strikes me that the flaw in all of this is when you're characterizing these as deals, they're not. They're impositions. When these entities are receiving funding or otherwise intervened by the government, they're not given a choice. All the fiduciaries that are ordinarily at these institutions are divested of jurisdiction. The shareholders are divested of jurisdiction. In the only example where shareholders retained jurisdiction in order to oppose a open transaction, which is the J.P. Morgan acquisition of Washington Mutual, of Bear Stearns, they managed to actually say you can't issue more shares, and therefore the price of the acquisition has to go from $2 a share to $10 a share. In every other circumstance, the board of directors has been removed of authority, shareholders have been removed of authority. So the first question that I have for you is this really a deal at all, and is there any way to have not an on-off switch in regulation by deal, but somehow preserve the rights of the corporate character and the corporate shareholders and directors in order to prevent abuses? The second is the flip side of that question. If you're going to regulate by deal, you should be subject to ordinary corporations law, state law, federal or otherwise, and the federal government is not. It is a sovereign actor. It's essentially immune because of sovereign immunity. You have very limited recourse under APA or other sorts of acts. And in addition, most of these legislative acts like HERA or FIREA or Title II of Dodd-Frank expressly take away from the jurisdiction of the courts the ability to look at actions that are within the ability of a conservator or receiver to effect, as long as it's within the character of those actions. So if we're going to be in a regime by deal, shouldn't the party that becomes a majority shareholder be subject to ordinary corporations law or subject to some sort of fiduciary duty as a majority shareholder?
Yeah, so there's basically 2 points there I talk about. The first is sort of my main area of expertise, which is M&A and the Bear Stearns deal. So the $2 to $10 was renegotiated because Wachtell made a mistake, and they sort of had a iterative vote where you could, if they voted it down, you held the vote again, you held it down, which basically gave Bear Stearns a year to try and find a better deal. So they recut the deal to give them $10 and make it a completely locked up deal, which if you're an M&A lawyer, you know you can't do that under Delaware law, which is where Bear Stearns is incorporated. And what happened is the shareholders sued on that basis in Delaware, which is voracious in keeping cases in its jurisdiction, happened to say, well, there's a New York case also, and we're going to defer to the New York courts on this one and let them take this Delaware case. So they refused to take the case, sort of the point the courts don't want to do it. And then the New York court, again, I think, said it was okay. on the decision, which, I think it's fair to say as a corporate lawyer reading that would not have been the case. It directly violated what we call the omnicare principle. But that's what happened in Bear Stearns. And I think the issue, sort of the second point, which is sort of the bigger issue I think you're getting at, is the government did cut deals, and there were negotiations, and in a sense, the government didn't cut as good of deals as it could have, right? It left a lot on the table for a variety of reasons, among which it didn't want to sort of take full ownership, for example, of Fannie and Freddie, because then it might go on its balance sheet. There's a special statute about sort of governing corporations that are owned by the government. There are ERISA issues. And so the government cut a lot of deals where it didn't negotiate as hard as it could have, some for legal reasons and some just because it didn't, like AIG and other areas. And so that's sort of the peril of regulation by deal, and it's something that I highlight in sort of the initial paper that came out.
Heath, you might be able to speak to this better than anybody. I think that sequencing mattered for the government, so that they were mindful of sort of the corporate rules and did try to reference back to laws that were ex ante, like the sovereignty issue as to the government. That's law. So I know it sounds a little circular, but I do think in reality there was attention to sequencing of actions, based on observing corporate formalities about the roles of boards and shareholders. Is that right?
Yeah, no, that's certainly correct. I think the larger question is, look, anytime you have the federal government at the table, you're not dealing with an equal. And so my view on that, and I'll use the bank regulatory context for that. I don't know of any bank or bank holding company that has sued the Federal Reserve, even if arguably they would have the legal right to do so. When you have a supervisor like the Federal Reserve over you, basically as almost a secondary board of directors over your board of directors, it's a lot harder to disagree with what they were talking on the last panel, an MRA, a matter requiring attention, even if you think that you have the ability to do so. The power, you're not coming to the table equally as in a regular contractual situation or most contractual situations. So I really think when you're in that realm, you really have to fall back on the separation of powers in our Constitution. Congress needs to play. If Congress doesn't believe the federal government is respecting the rights of private individuals, or when I say the federal government, I mean the executive branch, then Congress should step in. It should hold hearings. It should have passed statutes, laws, possibly having the courts involved, giving back some of the jurisdiction. So I would say that would be my solution. Is if ultimately we're worried about the over-encroachment of the executive branch on private actors, then the other branches at that point would need to step in.
There was a practical example of that happening with Merrill Lynch, Bank of America. A year of my life I would like to get back was spent on hearings with the House Oversight and Government Reform Committee, looking at the question of whether the government pressured Bank of America to buy Merrill, or if Merrill agreed to do the transaction, whether Bank of America agreed to do the transaction voluntarily. The bank's position is that it did so voluntarily.
Of course it is. But, I mean, just to pursue this, Mark, correct me if I misunderstood your question, but I thought the import was something like this. Suppose Congress now did step into it and said, all right, we will voluntarily say that if a crisis like that happens again and we end up on all these boards and throw out their directors and divest the shareholders of jurisdiction, all the rest of it, we will voluntarily cede sovereign immunity, our immunity, and pre-commit ourselves to certain fiduciary obligations, whether those are the ones of Delaware or something else. Is that it? Would that be a good idea?
Yeah, and so if you look at this in an FDIC context, through their own rulemaking, the FDIC, when acting as bank regulator and as bank conservator, self-restricts. And they say that they're going to accept a fiduciary duty even though it's not written into the FDIA. Shouldn't the same thing essentially be done with all these other pieces of legislation? Shouldn't there be some form of if we are traveling as a contracting entity, if we are traveling under state law or federal law, that we should be subject to state law and to federal law, at least within reason, not in an exigent circumstance in the takeover of a bank or takeover of a SIFI over a weekend, but 60 days later, 90 days later, something. Because to travel entirely as a regulator, but wearing a hat as a conservator or a receiver, seems unfair. It's not rule of law, it's pretextual.
Asked and answered? Or should we go, should we go to the next question, please?
This question builds on the previous, I think, to some degree. Can you hear me? Good. Max Smith from the Nuclear Regulatory Commission, of all places. And came here with some trepidation today. I wasn't sure this would be relevant to what I do on a normal basis. But I think conceptually there's a lot of similarities. Particularly one idea I think that we're familiar with is the peacetime, wartime distinction, and that the NRC sometimes is necessary to act very, very quickly and very expeditiously, and not with the usual due process protections you would typically use. One thing that developed in the wake of TMI, 3 Mile Island incident, was a provision of the NRC's act that the chairman can declare emergency powers in the event of a radiological emergency and then take on to himself or herself the entire powers of the body the commission would normally exercise. Do you see any similar opportunities in the issues you're discussing today, to now that we're in a time of peace, to plan for a time of war and delineate, what those wartime powers might be and how they'd be exercised with, the due regard we'd want to for the due process protection of law?
An emergency constitution for the fiscal sector or financial sector?
I'd like power to be as diffuse as possible. And look, we are in a world where we're about to start on a grand experiment with a deal maker in chief. And I'm nervous about that. And I would definitely like to see power as diffuse as possible coming into that. I don't like the idea of contracts kind of being negotiated, at the senior most levels.
Yes, sir.
Ted Murphy at the Congressional Research Service. The question I have on the art of the deal, this is a peacetime question, which is we've set up the FSOC with the authority to designate firms as systemically important, and then they get a different regulatory regime. And we can have 2 conglomerates that each do the same categories of activities, but different amounts of each. And with all due respect to the people that believe that there's a known definition of systemic risk, and then economists can add things up and get a number to it. In fact, you could have 2 firms each doing asset-backed securities, and under the could cause systemic risk element, the FSOC might say, oh, that could lead to fire sales on the collateral, so that leads to systemic risk for one of the firms. Another firm also doing a different category of asset-backed securities, the FSOC says, oh, great, you have collateral for your loans, there's a floor in the losses. So with that sort of discretion that's available in the designation process, is that the opening for the art of the deal and a vindictive, this couldn't happen. But what if someone got elected president and appointed the head of the FSOC, Secretary of Treasury, that had an enemies list and was vindictive on some firms and wanted to apply one standard for one and a different standard for the other, even though they're doing the same activities?
Well, to that, I was just going to say maybe the solution to that. I would hope that our public officials would, act ethically and unprejudiced. But transparency. I think one of the ways of getting to that would be increased transparency on the designation process. It may not get you all the way there, but I think more transparency in the FSOC process in particular would definitely advance the ball on those types of concerns.
I also think that, the focus of this panel in the last was on traditional sort of banking and sort of big banks, small banks, et cetera, investment banks. But, if there were a next financial crisis, if I had a guess, I think the point about cybersecurity and And that's going to come from places we don't even know, towards institutions that may not be important. If Charles Schwab's bank deposits I check in, they're suddenly changing every day, or they're not there, that could cause a mass panic just among all banks. So it's a big question that we haven't grappled with.
Yes, please.
Hi, Elaine Middleman. I'm an attorney in private practice. I should say I'm also a veteran of the first Chrysler bailout, which has been on my mind lately. When on television yesterday, we were talking about Donald Trump's nominees, and this is not a comment about Donald Trump, but several of them apparently became rich, and this is what they said on television, in the 2008 financial crisis. So what was it about that somehow presented an opportunity to these certain people where so many other people lost a lot?
Big Short. I don't have an answer beyond that. That's a great example. The Big Short's a great example. They were smarter. They saw it coming and they hedged. Yeah. Oh, real answer.
Richard Epstein.
Great.
Police. There had better be a question at the end, Richard.
Am I wrong when I say the movie I thought was quite accurate is what most people thought was that the tiers mattered and that the risk differentials could be accurately priced. And the people who made a lot of money essentially realized that if one of these classes went down, all of these classes went down. So they bought the premium stuff, right? And they paid very little money for their insurance, and they managed to clean up. And that's one of the things that happens is correlated risks really do matter in these kinds of cases. And if you think that you're going to have a situation where there's a nuclear attack on the system, at that particular point, all the gradations that would exist in normal markets don't exist. And the people who recognize that, I think, were the ones who made money. And the people who didn't recognize it were the smug bankers in the movie who simply says, we're willing to take your money because we know how the system works better than you. The intellectual mistake in this case was that I think people thought that the tails were really narrower than they were. And so what happened is when they tried to figure out how to run the institutions, the thick tail is what occurred, and the thin tail is what they prepared for, and that turned out to be a catastrophe. Is that correct? All I will say is that I represented Steve Eisman, who was the protagonist hero in that movie, and he really was that outspoken. He would go into rooms and tell people, "You're an idiot," and the like. Well, so I admire people further, like that. I spent my entire academic career, right?
Great.
It's for your brand.
Well, it's an exclusive brand. It gets a certain degree of recognition.
Yes, sir.
Jeff Naiman, a private practitioner. And this is almost maybe more of a comment, and it goes to peacetime more than wartime. But we see, particularly in the post-wartime era, we see the regulators very routinely saying, well, and they use we don't want to get back into a wartime situation. Thus, we are going to use enormous discretion in how we administer the laws. And the example that Reg Brown used of the CFPB, which is my principal antagonist, they do that every single day. We see it at the state banking regulator, the state mortgage banking regulator. All of these regulators are, in essence, enforcing as law their own personal preferences, things that they could never get into a statute, things they could never get even into a regulation. And it really is it's a considerable risk to our whole financial system of how much of the law is completely unwritten, and it's kind of difficult for our democracy in that none of it has gone through any kind of democratic process or administrative process. So I guess I'm sorry I missed. Am I wrong in saying that? Right? But it's something that I think it's worth, and I think it's really an outgrowth of the crisis. And we started kind of in our when we help clients look at acquisitions and so forth. we now have like a section, the Putin risk section, which is like what happens if the government in its many forms acts like President Putin and decides you lose and you win, right? And we see more of that happening in our country, not just in Russia, than we ever have, I think, in my career in the last 25 years.
The only thing I would say is that the founders in the Federalist Papers clearly warned of the rule of men as opposed to the rule of law.
You made a great point earlier about bad precedent being established. Like, no one should be able to cite Korematsu, right? We would all sort of agree with that, mostly, I think, most of the time. And, I would agree with that as a limiting principle, which is like stuff that happened in a crisis, like there's an asterisk next to it in reality.
To go back to peacetime for a moment, I mean, sort of aggregating and consolidating one of the themes I'm picking up from folks' questions, a lot of this goes back to something he said in response to one of the questions, which is, we have increasingly vaguely worded statutes. There are arguably many reasons for that. One, it's easier to get members of Congress to vote for statutes that are less specific. It's also easier in the sense that perhaps they don't have to own it. But, when you have a statute that is X pages and it's written in a way that necessitates, 200 X pages of regulations, you lose something both on the democratic accountability score, but also, you lose something on the democratic accountability score, but you also lose something fundamentally on rule of law, because there is less transparency, and unelected administrators are doing more of the actual quote-unquote legislating. And I think that is, whether it's by rulemaking or, as Reg points out, through enforcement actions, that is something we need to be mindful of as a general principle. I've been pretty clear that I'd like to see more responsibility returned to the Congress, because I think that's the closest place and the closest touch point that people and businesses have to affecting the policy that they're going to have to live by.
Yes.
I was one fellow at the George Mason University Law and Economics Center. It's just a short question. I wonder if the panel has to say something on the legality of deals like the Carrier or the Ford Motors recently done, and maybe Heath wants to say something about how to enhance transparency in those kind of deals where we can get to know about the exact terms.
Yeah, I don't know the details of those deals, so I'm sorry, I can't
You mean the
pass on
automaker bailouts?
Yep.
So TARP, so to talk about vague statutes, the TARP statute, as passed, allowed the government to buy any security of any company in the United States. That's the literal language, basically. And so they were able to use TARP funds to buy securities in the automakers. So I don't think the legality of that, in the sense that it had a statutory basis, is questionable. Now, what might be questionable, and there's sort of auto dealer litigation now about this, is sort of the government sort of negotiated a deal and sort of, as part of the deal, picked some winners and losers. And so the losers have been litigating the issue about due process in the courts, because there's fundamentally and always a due process issue.
Yeah, the TARP statute defined financial institutions pretty broadly, but basically it was any company that owned or controlled an insured depository institution of any type. So what that meant is that automakers who had a thrift or an IA, these various forms of insured depository institutions that weren't banks, they were captured. So in fact, under the statute, you could make, as Stephen was saying, you could make purchases in these companies.
Peter.
Trying to think through in U.S. history when would be a crisis response that panelists felt were defined by rule of law rather than rule of men. Thinking, for example, I mean, Hamiltonian discussions of state assumption of debt and central banking, there were statutory elements to it, but of course, the charge was exactly along these lines from Republicans. Shoe goes on the other foot with the Louisiana Purchase, exactly the same kind of idea. No constitutional authority for it. Congress is used as a rubber stamp afterward. And on and on and on. Is it possible that the rule of law commitment that we're talking about is become reified? That it itself, when you're talking about statutes passed by a previous generation to be picked up again to justify administrative action, what's the difference between that and rule of men? I mean, if you're using the exchange stabilization fund to bail out the peso or the dollar with ideas that look just anathema to the previous generation's conception when they put words to statute, how is that rule of law versus deal making, regulation by deal? How are those at all different when the statutory language is being stretched or bent or reinterpreted, as will always be the case when we look to pass statutes to justify present or future action?
Well, I would say there's probably a continuum, right? There's the rule of law rule of law issue is most acute when you have the executive or any branch for that matter going against the written law. So there are some examples of that, and people cite Abraham Lincoln, but I think, suspension of habeas corpus. He did a number of things that I think even legal scholars would say, flatly violated the law. There, I think, no, maybe. Okay. Some legal scholars, perhaps. Whereas in other instances, you don't necessarily have law that applies or is broad enough to be applied in a certain way and leaves some discretion. So I'd say, there's certainly a continuum. I think democracy and our republic is sort of most threatened when you have a system where the law is neglected or sort of, violated. And I don't recall many situations where that has been the case. Whereas, the Louisiana Purchase, there are some scholars that have argued, well, there is constitutional. In other words, there's a difference between constitutional interpretation and constitutional construction, the latter being a situation where the Constitution itself doesn't speak for or against it, but rather it's an opportunity for sort of innovation in thinking about the government's power. So I would say there's a continuum.
I don't accept the premise as to the Gold Reserve Act. I do think it has happened, and my examples would be more modern. The Affordable Care Act, the decision around taking the appropriation authority away from the Congress is just simply indefensible. And it happened, and everybody kind of looked the other way for a long period, and we are not currently in a crisis environment. The CFPB's action in the auto cases, where the law says you don't have jurisdiction over auto dealers, and so they kind of went through the back door to exercise jurisdiction over auto dealers and admitted it in a memo, and everyone sort of yawned. Those are the examples that make me very nervous and very worried, and I'm hopeful that as kind of people focus on these issues, they'll say that wasn't right and figure out some way to make sure it doesn't happen again.
Ken, last question.
A number of people, including you all on the panel, keep touching on impacts on the democratic system, little d. And so my question for you, and for something of this complexity, it seems appropriate, would be when you go from Congress and the process they go through to put a law in place, a case is made in passing that law for what it is, what it will do, what it will not do, and so forth. And then fast forward sometime later, then either the agency or in defense of agencies implementing it, the case is made, well, to protect it. Well, no, it's not that. Whatever was argued successfully through the congressional process. doesn't that have some of the more extraordinary potential consequences for undermining accountability, which I heard Bimmel talk about, and the democratic process itself? I mean, if you're a citizen, you can get to the other end of that and say, why did I vote? Why did I bother? And I hear a lot of talking around that, but that's happening in some courts, and I'm curious y'all's perspective on that.
Yeah, I mean, my perspective on this is, look, so let me make sure I understand your precise question, which is, if the intent of implementing legislation was X, but then the implementing agency comes out and does Y, people will think, you know, why did I vote? And I think where I will take this discussion, at least start, is there are those who say that the financial regulatory agencies shouldn't be appropriate, and there's a reasonable argument to be made for that. There's also a very good argument on the other side that they should, and you know, after a lot of thinking about it, I think I come out on the they should, because my view is, if the Congress of the United States and the President want to, you know, give away the store or take away, you know, to engage in policy that is bad for the macroeconomy and the citizens of the United States, the people deserve what they get. Whereas if, you know, if a presidential appointee whose term does not correspond with the presidential term, who cannot be removed at will, and who's otherwise insulated, engages in bad policy, it is harder, and the CFPB could arguably be a good example of this, for the people to have to have their say in the matter, right? Like, if an agency is divorced from democratic accountability, that makes it more difficult for the citizens to get due process. And, you know, I think that that's something worth being mindful of. The other side of that argument, and I'll cede to the rest of the panel, just to be fair, is the reason these agencies were set up is in theory for their expertise, right? And so the balancing act that you have to engage in when you're having these discussions is, what is the value of that expertise in complicated areas versus, you know, what is the value of democratic accountability and a touch point to the people. That's sort of how I view it on a macro level.
Well, and I can't think of a better question to end a session at the Antonin Scalia Law School than your question. And I think my answer would simply be this, to echo his a matter of interpretation. It's the words of the statute that need to matter. And if Congress intends something, then it better put it in the words of the statute. Because often what you see is the statute itself is really, you know, a convoluted mess of, you know, 100 different interpretations. And so my view in terms of the rule of law would be, look, if Congress wants to make its intent manifest, then it needs to, you know, enact a statute accordingly. And the agency at that point will be bound by the words of the statute. But
established by a state.
That's right. So that would be my response.
Hope springs eternal. Please join me in thanking the panel for a terrific discussion.